In 1994, a Treaty 72 claim began. As the European settlers began moving closer, the Crown had stated they had a duty to protect the Saugeen Ojibway Nation territory for its First Nations people. This protection was provided in the Royal Proclamation of 1763, the Treaty at Niagara 1764, Queen Victoria's Declaration of 1847, and the Proclamation of 1851 found in the Indian Lands Protection Act. In 1836, the Crown, through Treaty 45.5, assured the Saugeen Ojibway Nation that if they allowed land in the southern part of its traditional territory to be open for settlement, the Crown would protect the peninsula for its First Nations people forever. In 1854, the Crown said they could no longer protect the peninsula from European settlers, and the Saugeen Ojibway Nation should sign Treaty 72 in order to receive proceeds from the sale of the lands. The Crown breached its duty to protect the Saugeen Peninsula for the Saugeen Ojibway Nation. The land was to be allotted as the Crown saw fit. No proceeds have ever been received by the Saugeen Ojibway Nation. The Treaty 72 claim asks for the return of lands in government hands, national parks, roads, and shore road allowances, and compensation for non-returnable land and their loss of use, lands privately owned, as Treaty 72 was not fair or of equitable validity. The amount of compensation requested is $80 billion. In 2003, the Aboriginal Title Claim began, claiming title to the lakes and waterbeds in the Saugeen Ojibway Nation territory, which would allow for exclusive control of the surface water and fishing rights, as they had exclusive occupation before the 1760 British sovereignty. In Canadian law, rights to the waterbeds include rights to the water, the fish, the air above, and the minerals below the soil. The Saugeen Ojibway Nation is claiming compensation for the loss of the privately owned lands and revenue received by the government from the use of their land. With an Aboriginal title, the land is held communally by the First Nations people in a way compatible with their attachment to the land. Examination and discovery is scheduled to be completed in September of 2017. The parties set out their cases through evidence and legal arguments before a judge. That judge will decide whether Canada and Ontario are responsible for breaching their duties to the Saugeen Ojibway Nation and whether they have title to the waterbeds of Lake Huron and Georgian Bay.